All right.
Hello, good evening. My name is Maria Pantoja, and I'm here with my colleague.
Makopoulos-Senftleber.
And we're both from Lone Star Legal Aid. And today we will present to you information about wills and estate planning. Okay. Should I? And life insurance and trusts. I apologize, we were muted. So to get us started, what is a will? A will is a legal document that is prepared based on your wishes and requests to determine who inherits or benefits from your money, your property, or other probate assets. It may be used to exclude individuals who shouldn't inherit from you should you wish that. A will does not transfer non-probate assets, however. And examples of non-probate assets include life insurance with listed beneficiaries, payable on death accounts, joint ownership with right of survivorship accounts and assets, and retirement accounts.
I just want to know how much in each one.
Sure. The question was whether this presentation is going to be available, and yes, this presentation will be shared and will be available as well. General requirements of a will. So the testator must be at least 18 years old, married, or in the military, one of the three. The testator must have the intent to write a will, must be of sound mind, and to be of sound mind means that the testator knows the type of property that he or she owns, they understand that they're writing a will, and they understand the dispositions that they are making, for example, who they are giving their property to. And of course, the testator must sign the will. There are two types of wills that we're going to talk about today. One is the holographic will, and the second one is the formal will. The holographic will must be entirely in your handwriting. This means no other person can write part of it. It cannot be partially typed, no fill in the blanks type of forms. The benefit of a holographic will is that it does not have to be witnessed in order for it to be valid. So this is a good option for someone that may be in their deathbed that didn't have a will, or they want an updated type of will. The second type of will is a formal will, which is also a self-proven will. This one must be witnessed by at least two people over the age of 14, and it is usually typed. So this, along with the previous requirements, will make a valid formal will. So let's discuss preparing a holographic will. This is the one that you write on your own, entirely in your own handwriting. You want to start off with saying that this is your will. Something simple as my name is John Doe and this is my last will or testament. You want to write who you want to receive your belongings. You want to write who you want to serve as an independent executor. An independent executor is someone you trust to show the will to the court, to pay your debts, to give out your belongings, and essentially follow the dispositions that you are ordering in your will. And this can be the same person that is receiving your belongings, or that you are given anything through the will. They can take through the will. You also want your independent executor to serve without a bond. And to serve without a bond means that they do not have to pay any money to the court. They don't have to pay a bond. The courts usually require a bond to make sure that the money is not being stolen or misused. But if you trust this person, using this language makes it easier for them to serve as an executor. So you want to make it as easier as possible for the executor. So one, you want them to serve as an independent executor with not a lot of oversight from the court. And you also want them to not have to pay to the court in order for them to do their responsibilities as an executor. You want to put the date that you write the will. This is not a requirement, but it is highly recommended in case there are other versions of your will. You want to write in blue ink or sign in blue ink. Again, also, this is not a requirement, but it is recommended so you can distinguish your original will from any copies. And again, do not forget to sign the will. You can also self-authenticate a holographic will. And self-authenticating allows the court to accept the will as the true will of the testator. To self-authenticate, the testator must swear to and sign an affidavit before a notary stating that the instrument is the testator's last will and testament, and that the testator is of at least 18 years old, of sound mind, and has not revoked the will. Now let's move on to a formal will. What are some of the requirements? It has to be in writing. It has to be signed. And it has to be signed by the testator in person or through another person on behalf of the testator in the testator's presence and under the testator's direction. It must be attested. This is when there are two witnesses, at least of the age of 14, that they sign the will. And these witnesses must be uninterested witnesses. This means that they do not take under the will. A will may also be self-proven by including some affidavits. And a self-proven affidavit is a sworn statement used to authenticate the will so that the witnesses do not need to present themselves at court to provide any kind of testimony when probating the will. And the requirements are for the self-proven affidavit is that it has to follow a very specific form and content. In the Texas State Code, there is a specific form, and I'm going to show you an example of it following this. It must be made by the testator, and it must be made and signed by the testator and the witnesses before a notary. And the notary must affix their seal. And this self-authenticating affidavit must be attached to the will. And right here, we can see an example of what a self-proven affidavit looks like. This is a format. And essentially, the purpose of this is so that your witnesses do not have to go to court and provide any testimony in regards to the contents of the will or the legitimacy of the will. What are some of the tips to avoid will problems? As previously stated, you want to assign an independent executor to serve without a bond. You want to identify beneficiaries by name. So if you want to give your car or your house to your cousin, do not say my cousin and just continue with your disposition. You want to be able to identify which of your cousins. So for example, instead of writing my cousin, you want to write my cousin John Doe. It's also a good idea to assign alternate beneficiaries and an alternate executor. This is in case your executor does not want to serve or if they predecease you. You want to be specific with your requests, especially if there's more than one similar item that you are disposing of. For example, if you have a vehicle and a truck, it's best if you identify them by VIN numbers or be as specific as possible. The example here is your house. If you have only one house, they may be enough for the court, but you also want to either include the legal description or just the general address that identifies your house. So for example, instead of just saying, I want my cousin John Doe to take my house, you want to put, I want my cousin John Doe to take my house at 123 Fake Street, Houston, Texas, 77002, for example. As previously stated, you want to sign in blue ink to distinguish a copy from an original. And the reason for this is if you want to probate a copy, In theory, you cannot probate a copy of a will. You're probating a lost will. So there are other steps that must be taken in order for a will to be probated if it's a lost will.
I'm not understanding what you mean by probate and what is the definition of a lost will?
I'm sorry.
What do you mean by probate a will and what is the definition of a lost will?
Okay, so the question is, what is the definition of a lost will and probate?
Yeah. what do you
Okay,
mean
So
probate a will?
to probate a will is basically the process when you're presenting the will to the court so that certain dispositions may be, so certain dispositions may take place, to honor the will. The court has to review it and approve it. And normally it's a straightforward process unless it is being contested. Now, if you do not have the original will, which is a requirement to probate it, you can try to probate a lost will. So what you're saying is, I don't know where the will is, but these are the contents of the original will, and here's a copy to support what I'm saying. So when you are doing that with a copy, whoever is offering to probate the will has to take additional steps, including bringing in the witnesses, essentially trying to prove to the court that the original will was what you are presenting. And, it may include more evidence, like the witnesses or testimony that otherwise would not be necessary if you have the original will.
So you're just making changes to and which will?
You're not making changes. You are trying to prove to the court that the copy is similar as the original will. Because when you offer to probate a will, you need to also include the original will with your application to probate the will.
I'm trying to understand what probate means.
Yeah,
Okay.
so I guess to simply put it, when you have a will, once you die, unfortunately, there's no mechanism that just makes the will effective and makes it happen, right? There's nothing that makes the house go to your cousin or the car go to somebody else. You have to ask the court to make that happen. So you have to submit the will to the court.
Okay.
And that's called the probate
Oh,
process.
sorry.
And so the probate process,
Basically submit and initiate the will after that.
right, it's like getting a traffic ticket, like if you get the traffic ticket, that stinks and you have money owed. But the court that actually would enforce the fine if you didn't pay it is the way that actually happens and creates the enforcement mechanism. So it's kind of the same thing. You can think of a will as like a traffic ticket without an enforced fine. Nobody's gonna help make those things in the will happen, but the court is gonna be that arm to push those things to happen. And to do that, you have to, it's called probate the will, but really it's sort of like registering the will with the court. And then it also gives the opportunity for people to contest it. So you've heard, I'm sure, horror stories about nasty family dispute.
Right.
Those are when Aunt Tina comes out of the woodwork and says, no, she didn't really want to give it to her kids. She wanted to give it to me, her beloved sister, and she gets to entertain testimony in the court to sort of fight that will. So that is basically the forum by which the will gets proven as valid. And the court says, if the will is valid, that the dispositions in it can be enforced and effectuated. Does that help explain it?
Right, so if the original will, is it ever filed with the court?
It must
Okay.
be filed with the court.
Yes, and it must be filed with the court to probate it. And so what Maria's saying, if God forbid something happens to your original will, and all your person that's getting it, one of the beneficiaries is left with, or somebody else is left with, is a copy, then they have to take extra steps to show the court that this is a valid will, because the court doesn't want to honor just a copy. They want the original. And so there's different standards, legal standards that the people that are proving the will up in probate will have to meet that make it way more complicated than if they were to just have the original will. Because it's really hard to argue that an original will is invalid. There's much fewer arguments to attack.
Okay, so let me get this clear. Your original will already be on file in court, right? But if there's some changes after that, or it's lost for some reason, and someone says we have another version of the will, then that's where all that comes into play, right?
It could. The will doesn't get filed with the court until the person that the will is for passes. So if you don't tell your beneficiaries or someone trusted where you keep the original will, and they can't file that with the court, they only have a copy,
Oh, okay.
then that becomes a problem because the filing isn't happening. Unfortunately, I can't say, let me just go ahead and file my will right now while I'm still alive so I can make sure it's okay. It has to happen after you pass. So it's out of your control if you don't take the steps to make sure that the people that need to know where it is, know where it is.
Okay.
And they know where the original is, not the copy. Because it's great if you give somebody a copy so they know what's going on, but that's not going to help them when they actually need to go through the probate process.
Okay.
Does that make sense?
Right.
Cool.
Perfect.
Okay.
Thank you.
Yeah.
So another tip is also to number and initial every page. And don't forget to sign. I'm repeating that a lot because sometimes there's drafts, but people forget to sign it, and that also renders the will invalid. You want to keep it in a safe space and make sure people that know where it's kept. And the people that we recommend would be like the executor and your beneficiaries, for example. And again, just like Pete said, you want them to know where the original is to avoid having to present a copy and then have to go through all those hurdles in proving up the will. Okay, so now that we talked a lot about wills, we want to move forward with powers of attorney. And a power of attorney is a document, it's a legal document that gives someone the legal authority to act on your behalf. So they're stepping in your shoes. The person appointed in the power of attorney is called an agent. And the person who signs a power of attorney making someone else their agent is the principal. So if you are executing a power of attorney, you would be the principal. We're going to talk about 4 different types of powers of attorney. First is the general power of attorney. This gives the agent the authority to act in a broad range of matters. And it ends when the principal becomes mentally or physically disabled or incapacitated. I think we might be having issues with the slides.
Well, sorry, there's some questions coming up and I don't know.
Okay. Limited or special power of attorney is another type of power of attorney. And this is more specific. It is giving the agent the authority to handle a specific matter or only gives an authority, the authority for a very limited period of time. The durable power of attorney. This is very similar to the general power of attorney, where it gives the agent a broad range authority for a broad range of matters. But unlike the general power of attorney, this one continues to be effective even after the principal becomes mentally or physically disabled. And the last one that I want to touch on is the medical power of attorney. This gives the agent the authority to make certain medical treatment decisions if the principal becomes mentally or physically unable to make their own decisions. So what are the requirements for executing a power of attorney? It must be signed before a notary public. The principal must be 18 years of age or older. And the principal must be of sound mind and understand what they are doing when signing the power of attorney, which means that they have capacity. And what I have seen in the past is a lot of times people want to use a power of attorney as an alternative to a guardianship. A guardianship is basically when someone does not have the capacity to make their own decisions, so someone else has to be their guardian to make certain decisions. But if the person executing the power of attorney does not have the capacity, that power of attorney is not valid. So they have to go through the guardianship process. That's a whole different discussion. But a lot of people think that, you know, when someone doesn't have the, let's just say a disabled child, for example, that may not have the mental capacity to make their own decisions once they turn 18, some parents may think that as long as they have a power of attorney, that they can continue making certain education decisions or medical decisions, and that's not the case. They need to go through a whole different process, because if you do not have the capacity, you cannot execute a power of attorney. That's key for a power of attorney. They need to know what they're doing. Now, if the power of attorney is being used to conduct real estate transactions, another requirement would be that the power of attorney is filed with the clerk of the county where the property is located. Before we discuss the next subject, something that I want to stress is when you are designating an agent, you are giving someone a lot of power over your decision. So you want to make sure that you designate someone that you really trust, someone that you trust with your life, because they are making decisions that can affect your life. And power of attorneys are revocable. And we recommend that if you are wanting to revoke or change a power of attorney, you do it in writing. So now I'm going to pass this over to my colleague Pete, and he will be discussing advanced directives.
Great. Thank you, Maria. So we are going to talk about advanced directives. I know we're covering a lot of different topics today, but I think at the end is a really good opportunity to chime in and ask questions about what these things are. Because sometimes people think, okay, there's a will and then there's power of attorney. Power of attorney covers everything, your medical, your financial, all of that. That couldn't be further from the truth. As you're seeing in this presentation, as we're going to explain, there's all different little mechanisms for decision making, and they all have different legal requirements. So there's wills, there's the 4 types of powers of attorney that Maria talked about, and then there's also advanced directives, which is what I'm going to talk about. Advanced directives are legal documents made in advance that directs family, physicians, and others on actions that they should or should not take on the principal's behalf when the principal can't communicate their wishes due to an illness or incapacity. So we're using the same terms here. Principal is the person signing the document or giving the directive, and the agent is the person that's going to be taking on that role to make the decisions in the event that principal becomes incapacitated. This, like a will, should be carefully tracked in terms of the original documents. You want to keep track of the original, know where it is, and make sure that the people that should know where it is, your agents, know where it is. You also should make copies of this and give it to the doctors and agents that are being affected by it. So if you have a certain primary care physician or a hospital that you get treatments at, you want to make sure that those routine practitioners have copies of any advanced directive that you write, giving authority to make these decisions to another agent. This way, there's no lag time or issues with handing that authority off or making clear what advanced directives you have in place. There's a few different types of advanced directives. So there's directives to physicians. This is where you give certain directives to your actual care provider. There's medical power of attorney, which is something Maria talked about earlier. And then there's out of hospital, do not resuscitate, or DNR. If you've been hospitalized, you may have received a DNR form to fill out, basically telling the hospital, I do or I do not want to be resuscitated if I lose consciousness or need resuscitation. You can already draft one of these and have it ready for out of hospital situations where you may be subject to emergency medical care by an EMT or an ambulance. So here's a little bit more detail about what directives to physicians and families or surrogates are. Some people call these a living will. And what it does is it states the principal, you drafting its wishes about withdrawing or withholding life-sustaining procedures if your condition is terminal or irreversible and death is imminent as certified by 2 physicians. So this is commonly when you think of the scenario of, pulling the plug, so to speak. Do you want to give somebody else authority to make that decision for you? Who do you want to give that authority to? And what do you want that decision to be? Do you want to be kept alive and on life-sustaining equipment if 2 physicians do say that your condition is terminal or irreversible and that death is imminent? Or do you want them to go ahead and pull the plug, so to speak, and make that decision to terminate your life? It's a really tough decision. So if you are drafting one of these advanced directives to your physicians or to a family member, you want to make sure if you're giving that decision to a family member, it's to somebody that you trust and will carry out your wishes and make the decision that you want to. Or if you're not exactly sure what you want that decision to be, you're comfortable with the decision that they are going to personally make. Medical powers of attorney, Maria covered that, but I'll again reiterate, this gives the power that the principal has to name a person they trust as an agent who's authorized to make medical decisions for them when their doctor determines that they're unable to make their own treatment decisions. So some people think, well, if I sign a medical power of attorney right now and I allow my spouse to make these decisions, they can start making these decisions for me right now. Or if I'm in the doctor's office and I don't want to answer a question, they can just go ahead and do it for me. That's not how this works. It's only effective during the time that you, the principal, are incapacitated. So if you can make your own decisions and a doctor doesn't think you're incapacitated, you have capacity to make those choices, your power of attorney isn't effective yet. It's only effective when your doctor says, you don't have capacity. And typically capacity is a pretty low bar. So if you're able to talk or gesture or function and comprehend, then you have capacity. If you are, God forbid, in a coma or something where you truly do not have capacity, that is when that medical power of attorney takes place and your agent can make decisions about your medical care, whether you should have a surgery or something like that. The second that you, the principal, regain capacity, you come out of a coma, you are out of a surgery where you're under anesthetics, then the power of attorney dissolves. It no longer exists anymore. You're back in the driver's seat as the principal. And then it will only go into effect again if you become incapacitated again. Out-of-hospital DNRs, these direct emergency medical professionals not to resuscitate you and allow you to die a natural death if that's what you would like. It does not affect treatment designed to make you, the principal, more comfortable. So if you were in a condition where you needed some sort of drugs to make you more comfortable, the DNR would not cover that, or to reduce your pain. Emergency medical personnel can honor this type of DNR, and not the directive to physicians or a medical power of attorney. So this is for EMTs or emergency medical personnel. They can honor that DNR, but they do not get to honor the directive to physicians or the medical power of attorney. Those are only effective when you are under the care of a physician, not an emergency medical personnel. All right, you had a fantastic question, which is what is probate and how does it all work and why does it happen? Take the feeling that you have when you get a notice that you're on jury duty. I do not want to go to court. That's how almost everybody feels. Even lawyers don't like court. Nobody wants to go to court. It's not fun. It's expensive. It takes a while. And quite frankly, it's pretty confusing. So in my opinion, the best way to dispose of as many assets as you can is to make things non-probate assets and non-probate property. What that means is there's certain things that you may own or have in your possession that you can get out of the probate process so that your beneficiaries, your family and friends, the people that you want to leave these assets to, aren't sitting around waiting for Aunt Gina to contest your will and aren't waiting for Judge Jones to say this will is valid and you can now proceed and get that property. It happens instantaneously upon death of the person who is disposing of the assets. How do you get that to happen? There's a couple of different ways. It depends on the property and property type. So there's several different non-probate transfers. So these are things that they aren't going to go through the probate process like your will. Once you have some of these in place, it takes them out of having to be probated. It makes them effective upon death of the person who wrote them. So these are transfer on death deeds, or sometimes they're referred to as TODs. Transfer on death deeds for motor vehicles, so a TOD for your car. Joint accounts or tenancies with right of survivorship, life insurance, and trusts. So these are all non-probate transfers. So how do these work? Let's talk first about transfer on death deeds or TODs. So this is how you can transfer real estate to somebody else after you die without the need to have the court proceeding necessary if the real estate was transferred within your will, which would be through probate. So you can transfer land, homes, buildings. I don't know how many of you have uncut timber lying around that you want to give to somebody, but if you do, you can do that. And mineral rights. You can also give mineral rights. One requirement of a TOD is that it has to be recorded in the deed records in the county where the property is located. So if your property is in Harris County, you want to make sure that once you have completed your transfer on death deed, you record that in the Harris County deed records. With a properly recorded transfer on death deed, you don't have to probate to transfer the real property. So that home, I think, is the easiest way to talk about it. If you don't have a will or a TOD, your real estate must go through the probate court and your property will pass to your heirs according to Texas intestate law. If you have a will, it will go to who you want it to, but it still has to go through the probate process. If you have a transfer on death deed for your real estate, you get the property to who you want it to, and you don't have to go through the probate process. And I think it's confusing. I shouldn't be saying you because you're not going to be going through the probate process. If this is your will, it's going to be the family members, all of your beneficiaries that you left behind who are going to be stuck with this process. So with a transfer on death deed, you decide in advance who should inherit your real property interest, and you avoid having to make them go through the probate process. A TOD allows you to keep all ownership rights to your property during your lifetime. So you don't have to be afraid. If I write one of these, even though I really want to give this house to my son, does that mean this is my son's house while I'm alive? No, it's your house while you're alive. The second you are declared deceased, it becomes your son's house. So the property can be sold, placed as collateral on a loan, and all the fun things we get to do with our property can be done only by you, not the person that's going to get it as designated in your TOD until you're deceased. And at that point, hopefully you're not worried about it. After your passing, the beneficiary has to file an affidavit of death in the deed records to get the clean title. But just filing an affidavit of death in a deed record is so much easier than going and probating a will and waiting on the probate process. It's more of an administrative task that beneficiary is going to have to do. All right, so how do this sounds great. My family members will get to avoid probate. I'll get to keep my house while I'm here. Gives everybody less things to worry about it. How do I create what's required of a TOD? So it has to be in writing, signed by the owner and notarized. It has to have a legal description of the property, and you can find this on the deed to the property or in the deed records. Don't use your tax roll information because that's usually not right. So make sure if you're going to draft a TOD or get one drafted, you're using the description in the deed to the property or in those deed records. The transfer on death deed must have the name and address of one or more beneficiaries. So again, don't just use my cousin, use my cousin John Doe or John Doe at 123 Main Street, Houston, Texas. And then it also must state that the transfer will happen at the owner's death. And finally, it has to be properly recorded during your lifetime in the deed records in the county in which the property is located. So this takes away that other problem. I have to tell people exactly where everything is because once I'm gone, it's going to be up to them to figure this all out. And how do I make sure that happens safely? A TOD gives you the opportunity to do everything you need to do before you pass. So all you have to worry about once you pass, well, hopefully you're not worrying about anything in the afterlife, but if you were, all the beneficiaries have to do is file that affidavit of death once you pass, and then bam, the title transfers. So who can be a TOD beneficiary? It can be a person, an organization, a trust, a charity, or an institution. You don't have someone you love you want to leave it to, you want to leave it to your church or your community center, you can do that. You can name an organization in there. You can name more than one beneficiary. You've got 3 kids, you can put all 3 of them in there. You do have to make sure that you are specific. You give their name and address. You can't just say all my children or my cousin or every grandkid. Those aren't valid. You have to make sure you list each and every one. And then this is a little weird, but it's just something that we have to do because it's Texas law. The beneficiary has to survive the person that left the property by 120 hours or 5 days. Otherwise, the transfer isn't valid unless there's an alternate beneficiary. Some people ask why that may happen, except for just really bad luck. Say, for example, God forbid you're driving your car down the highway, you and 2 of your beneficiaries are in the car, you get in an accident, you pass away instantaneously, the people in the car pass away 3 days later. If you had a transfer on death deed leaving something to those other people in the car, it would not be effective because they didn't survive you by 5 days. So then your property is back to either what's in your will or an intestate proceeding, meaning what happens when you don't have a will, where it just goes by Texas law. So for that reason, because you never know what's going to happen, those terrible bad luck scenarios do happen to some folks. It's usually a good idea to name alternate beneficiaries. And so that would say something like, if to all of my children, you list all your children. If they are not alive, to grandchildren, A, B, C, D, and you list them as well. Beneficiaries don't have to sign the todd, but they do have to file that affidavit of death after the person giving the property has passed so that they can get their legal title. Oh, now I'm going too fast. All right, so these all sound good. Sounds like transfer on death deeds are the best thing. They have nothing wrong with them. That's not true. Pros and cons to everything. Benefits of a todd. It doesn't affect your rights while you're alive. You can still do everything you want to with your property. It doesn't give anybody the right to your property while you're living. You do not need the beneficiary's permission to sell or mortgage your property. It avoids probate, which is legal fees, attorney's fees, waiting, just a lot of time, and could be subject to contest. You can transfer the property even if you're not done paying it off. It's also revocable. You can write it now, and 5 years later, you and your spouse have a falling out and you don't want to give it to him. You want to give it to somebody else, or you and your son have a falling out. You want to give it to somebody else. You can revoke it. You can write a new one. You cannot do anything. The property is not subject to Medicaid estate recovery. And this is the state's way of recovering for Medicaid and long-term care services if support is provided to the person who wrote that deed. So it protects it from that collection liability. Here are some cons to a transfer on death deed. They have to be filed in the county where the property is located during your lifetime. So if you write a transfer on death deed that's 100% valid, but you forget to file it, or it just falls off your radar, then it's not going to be honored. It has to be filed during your lifetime. Your beneficiary can't file for you after you pass. You can only transfer or share what you own. Yes.
You made a statement earlier, so without a todd, say for instance, your property, could be used as repayment for Medicare or Medicare or some type of benefit that was received during your lifetime.
Mm-hmm. Yes.
How does that work? Like if someone was receiving Medicare and what they had outstanding?
Yes. So there's
a percentage that they would normally pay for a bill or something like that?
Yeah. So the question was, without a todd, is the property subject to Medicaid estate recovery? And really, how does that work? What is that? Yes, Medicaid estate recovery is where Medicaid is permitted to recover from certain income or assets of the person who was getting services for certain outstanding services that were unpaid for.
Okay.
So with the todd, they get shielded from that recovery. Without one, that can be taken from the property and other assets. There's a list of assets, and that's a whole nother discussion. But you can, if you search for Medicaid estate recovery, it outlines which assets are collectible and not, and which income streams are collectible and not. All right, it doesn't shield the property from creditors. So aside from that Medicaid estate recovery protection, it doesn't mean that people that have liens or creditors that have claims against the property get shielded from it by virtue of the TOD. Those are still valid and will exist up against it. So you can't have a house with $500,000 in liens with it, all get forgiven when you pass it down. Those will remain in effect. If you have someone designated as getting your house in your will, and let's say you designate your daughter to get your house in your will, and then you have a TOD where you designate your son to get that very same house in your TOD, the son will get the house, not your daughter. Even though she's getting it in the will, your son's getting it in the TOD, and the TOD trumps the will if your beneficiaries are different. So if you do have both, just make sure your beneficiaries are the same so things are going exactly the way that you want them to. A power of attorney cannot be used to execute a TOD. So if you give power of attorney to somebody else and then that person tries to write a transfer on death deed for you, that will not be valid. You can do it for a house. Can you do it for a car? Yes. An owner can designate a beneficiary to whom interest in a motor vehicle transfers upon your death. So these are your primary assets. Most people, when they're thinking about what they're leaving after they pass, it's going to be a home and sometimes a vehicle or two. So you can have a TOD for a vehicle as well, and that would take care of 2 or 3 primary assets for you. Like a real estate TOD, a designated beneficiary doesn't have any interest in your car until you pass. Only individual owners, not entities. So remember, you can write a TOD and give your house to your church or a business that you love. You can't do that for a motor vehicle TOD. It can only be to a person. A beneficiary can be designated, changed, or revoked using a couple of forms. This PowerPoint is going to be sent to you guys, so you'll be able to click on these hyperlinks, but these are published by the Texas Department of Public Safety, our DMV. So you'll use this beneficiary designation for motor vehicle form and an application for Texas title and registration form. And you'll also submit a title application fee and valid ownership evidence to a county tax assessor collector's office before the owner is deceased. So again, this is a way to kind of get everything in line so you're not wondering if things are going to work out or if you did enough to set the beneficiaries up for after you pass. All owners of the vehicle have to sign the form. So if you and your spouse or your child jointly own a vehicle, make sure all of the owners of the vehicle sign the forms. And these, again, have to be original signatures. Same rule as the real estate one, the beneficiary has to survive the owner by 120 hours or 5 days. And then to actually claim the vehicle, the beneficiary has to submit one of these forms, an application for Texas title and registration, and the owner's death certificate. And that needs to be done no later than 180 days after the owner's death. So make sure if you do have one of these, you let your beneficiary know, hey, make sure you do this within 6 months because then it's going to expire and it's not going to be valid. So they need to be on top of getting these submitted. A beneficiary gets the vehicle subject to any liens. So if you have a $20,000 loan on your vehicle, it doesn't evaporate just because you gave it to a beneficiary. They only own the vehicle with that lien on it. They can disclaim interest if they don't want it for whatever reason. They don't want to pay the registration fee. They don't want to pay taxes, whatever. They can say that they don't want it even if you've given it to them.
Can they, request that the estate pay the lien on the vehicle or whatever property? Like if the home or the vehicle or what have you had some type of lien on it and you had a TOD on it, could the beneficiary of the TOD request that the state pays that lien?
So the question is, and I'm repeating this just for the benefit of the people listening remotely, could the beneficiary ask the estate to pay any taxes, transfer fees, things associated with the vehicle if there was a TOD? The answer to that is a little complicated. Yes, they could ask for that. would they get that or would they be entitled to that? I don't see any legal way that they could
No.
be entitled to that.
You would have to open up the probate procedure to ask for the estate funds. You're saying the estate, right? Not the state.
Right, because the title would trump the will, so normally the property of any liens and things like that would have to be paid from the estate before they can get the property, right?
So the property, whoever inherits through the todd, they inherit subject to any liens or any taxes. So to get the estate to do anything, you would have to open up probate, and that would be the purpose of the todd.
Okay.
I mean, the todd still stands, but you're directing or you're asking the court to approve certain funds to come out from the estate to cover other unrelated. And then there's a certain order where the court may approve certain funds of the estate to pay certain debts. And that is likely not one of the priorities in the list. Now, there may be creditors, secured creditors, funeral expenses that may need to be paid before anything else gets taken out of the estate to cover certain expenses. So you can request that from the court. Whether it would likely be granted is.
I would say probably highly unlikely. So
Yeah.
you could ask, in theory, that person could ask if there was a probate proceeding, they could intervene, or if they were already in it in some way, like they were getting some other asset and they were a party to it, or they were the executor, they could request it, but would a court grant it? Like Maria was saying, the way the court usually works on that is they operate on a priority list. This would be, I don't even believe it's on the priority list, so it would really be up to the court's discretion, and I don't see that getting granted. All right, so those are motor vehicle TODs. Something else, joint accounts with rights of survivorship or joint tenancies. So these are when one or more persons own a certain item of property. This can be real property like land, or personal property, some sort of object or account, and they can be owned jointly. A joint tenancy is when one owner dies and their share of the property passes to the decedent's heirs or beneficiaries. A joint tenancy with right of survivorship is when an owner dies, the share of the property goes to the other owner. So for example, if you jointly owned a home, if there was a joint tenancy with right of survivorship, that would mean the other person that owned the home with you when you passed would absorb your share, so to speak, in one of those situations. A joint tenancy with right of survivorship is not automatic. It has to be created with a written agreement. It's not necessarily covered in this slide, but something that kind of falls in this category, but kind of doesn't, it's a little bit of a different creature in my opinion, are payable on death bank accounts. If you have a bank account, a checking, a savings, with a bank or credit union, most banks or credit unions have payable on death forms that you can complete at the bank. You just need to ask for one to designate who you would like to receive the remains in that account upon your death. That's another way to keep an account or a piece of property out of probate, because one of those payable on death forms, when completed and registered with the financial institution, is a valid way to get that asset out of probate. So if you have a $5,000 checking account, you can say, I would like this payable on death to my son. And then upon your death, son would go to the bank, say there is a payable on death designation, here's the death certificate, and the bank would be allowed to release the funds to son. They don't have to go through a court process or do anything complicated to get those funds. It can get tricky if you have several different bank accounts and you need to do these with each of your bank accounts, but it's a lot easier to just fill out a simple form up front, in my opinion, than to subject these accounts to being a part of your probate estate and then having that take a while to figure out where it goes. Especially if you have simple beneficiaries, if you know you want to leave it to, 2 children or 3 grandchildren or a spouse. But that's another step you can take. It's similar to a joint tenancy to designate who that money goes to and keeps it out of probate. Life insurance. Life insurance is also a non-probate asset when you have designated valid beneficiaries that can collect. A lot of times people will only name one beneficiary. And unfortunately, that beneficiary could predecease them and they forget to update the beneficiary. At that time, your life insurance has no beneficiaries because you didn't designate an alternate and that person passed. That would kick those insurance funds likely into your probate estate. And so then it would have to be determined by your will or follow the Texas Estates Code for an intestate proceeding. So my recommendation usually is to have alternate beneficiaries because that prevents that scenario from happening. And it doesn't take anything away from the person you've designated as your primary. It's just a just in case catch-all. Doesn't really hurt anything to have, and it could help a lot. Life insurance provides money to your family after your death to help them pay for burial costs, living expenses, bills, and other expenses. So some types of these policies can give benefits while you're still alive through cash values and accelerated benefits, but most of us, we know life insurance is just a lump sum that gets paid out after you pass to your beneficiaries. In general, life insurance is a good idea if you have family or other people that rely on you financially because it gives them a lump sum or in some cases sporadic payments so that they can support themselves. So if you're looking at life insurance, you want to decide what amount would be a good amount to leave to your beneficiaries. Think about the debts, the amount of income your family has to replace if and when you pass, and whether they're going to have bills and other expenses that they'll need to pay. Life insurance benefits are non-probate property that pass outside of probate to the persons named by the person who has passed, the decedent, in the appropriate beneficiary designations. These assets, like we just talked about, can be probate property if there's no beneficiary designation or if the designation is not valid. One note here, in some cases, if you've designated your spouse as the beneficiary on your life insurance and then you get divorced before you pass, sometimes that designation can be invalid if you do not redesignate your ex-spouse after you get divorced. I think that rarely happens where you still want your ex-spouse to have your life insurance money, but sometimes it does. And so if you did want that to happen, you would need to redesignate them again after your divorce proceedings. Another piece of non-probate assets are living trusts or inter vivos trusts. These are created while the owner is alive and it's treated like its own entity, the trust is. And this is created for the benefit of another person. So a trust in the interest of my son. If I created that, it would be for the benefit of my son, and the trust itself would be treated like an entity or a business, really. The owner conveys the property to the trust to be managed by a designated trustee. So you can name the actual person obtaining the benefit, the beneficiary as the trustee, or you can name somebody else. A trust in the interest of my son, and the trustee is my wife. And so this way, the wife is managing the trust, the beneficiary is my son. You can make them different or the same. Depending on the terms of the trust can continue after the owner's death, but not longer than for one life and being plus 21 years. That sounds confusing because it is. It's every law student's least favorite thing in law school to learn about. The easy way to think about it is this. Make the trust in the interest of finite people who are alive when you're here. If you're making a trust to mystery grandchildren to be born at any time in the future, that's probably not going to be valid. Even if you have existing grandchildren but you say all my grandchildren, well, whether you like it or not, grandchildren can still be born after you pass. So it might be invalid if you just say that. Make things simple, make them efficient, and keep them legal and enforceable. People that are living once you pass. Otherwise, you have to deal with this funky language of continuing no longer than 21 years plus one life and being after you pass. Nobody wants to think about what that means. So don't make them, just name real people. The cons about these kind of trusts is they have high federal income tax rates and they're subject to annual administrative costs. So that's one reason people sometimes don't use living trust, is because you're paying a lot to manage them usually. All right, probably why you guys came here. Resources, where can I go to actually get these things get more information on these, or maybe even draft some of them on my own. We're going to send out this PowerPoint so you can click on these and they will mean more than just blue underlined text. Texas Law Help is an excellent resource that it describes in detail some of these things. I know we talked, probably I talked too much. Maria talked the perfect amount. But there's still so much more. We're scratching the surface on all of these different things. So Texas Law Help can answer frequently asked questions. They already have, and they're all printed up online. You can just search through them. And they also provide certain forms so that you can actually look at what these things look like. And some of these you can even fill out on your own. The next link is the Texas Transfer Toolkit to assemble your own real estate TOD that can be used so that you can input your own information in there and create a real estate TOD. And then there's also one for motor vehicles so that you can make one for one or more of your vehicles. And then finally, this final link will be Texas Health and Human Services forms to help you draft a statutory durable power of attorney. So that power of attorney that can make those decisions if and when you become incapacitated. And so those, like I said, will be emailed to you so that you can actually click on them and access them. But if you start at Texas Law Help, it'll take you to some of these resources. All right, you already chimed in with some really great questions, but any other questions after hearing all that?
Okay, like, yeah, you got a lot of information there, with the handle there. The lady asked some good ones. I don't even know it. But, instead of, of course, you're not giving out handouts instead of going for the resources, but, well, like say this holographic will or the formal will, just to break it down, should one go to a lawyer? That way they give you all the information, just like we're giving it here, and how much will it be, and what's the going rate now? And a good lawyer, not a public defender lawyer.
Well, I don't think we can speak on rates because we
Yeah.
are a nonprofit, so we don't have that information. We're always going to advise to go with an attorney because, we do this often, so we want to give you the best advice for the facts that apply to your specific facts. So when you ask, should someone go to an attorney? My opinion is yes. What is your opinion, Pete?
Yes, my opinion is usually yes. A holographic will, in case it wasn't clear, is more like a simple, I think Maria said it, on your deathbed kind of situation, or like now during the pandemic, people have been writing them because they couldn't get into a lawyer's office or get an appointment and were worried about what might happen. That is entirely in your own handwriting. It's really simple and informal. Could you do a holographic will yourself, like as a placeholder? Yeah, you could do that if you have no will whatsoever. It's probably a better option than nothing to do a holographic will on your own, just kind of following those tips of make sure it says it's your will, make sure it has your name, make sure it's all in your handwriting, you sign it, you date it, you use blue ink.
Forget about notary, you're like an in-law or.
You don't need a notary for a holographic will. You don't need a witness. You don't need a notary. You can write one right here as we sit, and it could probably be valid just following those tips. My favorite story about a holographic will is a farmer was getting crushed under his tractor. He took a rock and wrote "all to wife" on the fender of the tractor. They brought that fender into court and they upheld it as a valid will. He wrote "all to wife" and his initials. That was enough. So a holographic will is really like an emergency placeholder thing, in my opinion. It's a valid will, but I prefer and usually tell people, if you can, go see a lawyer, get a formal will drafted. But if you want to make a placeholder for whatever reason, better to have than not have one at all. You can do a holographic will. The formal will, you can write it on your own, but you can also get an attorney to write it. I think both of us recommend that you get an attorney to write it. As to how much it's going to cost, that depends on which attorney you go with. If you're searching for lawyers and want to see their rates and read reviews about them, there's a really good website, avvo.com. It's kind of like Yelp for lawyers, and you can put probate or estate planning or choose the kind you want and put your zip code. It'll give you all their names and reviews, and you can sort through and select one for yourself.
And something else about a holographic will, let's say you have 5 children and one of them wants to contest your will and they want to say it's not your handwriting. That's an issue that you wouldn't have with a formal will. Now here, if it's a contested matter, now they have to go with the court, bring maybe an expert and handwriting, they have to jump through different hurdles just to, prove that that was your handwriting, that even though it's valid, sometimes those informalities may create some more issues when, probating the will, especially when it's contested. So, again, my preference and my recommendation is always a formal will unless it's an emergency. Not long ago, I think I was seeing, or hearing about inmates doing a holographic will because they can get witnesses in jail, to get it notarized, especially with the pandemic. So, that's one of the situations where maybe a holographic will, may be more convenient, aside from, the death. Someone might not have access to witnesses or a notary.
Other questions about wills or anything that we talked about?
I'd just like to add, there's a nonprofit organization like you guys, Covenant Community Capital.
Mhm.
You've heard of them? They work with, lawyers and things like that to offer the services of doing and preparing a, traditional will, for those low income, things like that. And if I'm not mistaken, I think they do, estate as well, but I know for sure, wills. So that may be someone to contact if, as far as from a financial perspective, if you want to get a professional to assist you in drawing up your will, they actually sit down and help you do an actual will. So I was in one of their seminars one time, and it's been so long, I don't know exactly who the professionals were, but they came and did a presentation like you guys, and they do that on a regular basis. They offer those services, for free. Just FYI.
All right.
Thank you. And you may also, apply for our services, for Lone Star Legal Aid. And, if you qualify for our services, it may be something that we can assist.
I did one while back, I forget exactly what it was, we were there every Friday at the Makopoulos-Senftleber Hospital. The veterans.
Might have
place.
been, yeah. they're in June.
And I went there and I put me and my wife in and said, you guys said, I earned too much money.
Yeah.
I true story, so, I mean, not that I'm poor, they're poor or whatever, but yeah, that's what happened, that surprised me,
So you guys offer the services for will and things like that as well,
Yeah.
like helping someone to prepare that?
Yeah.
I don't know if I do it again.
Yeah, let me
Don't
get,
start.
It's worth a shot real fun, financial guidelines change, and they have changed, so.
I forget what I think specifically it was for, maybe it was the will thing, and then I think, yeah, I can't remember, about 4 or 5 years ago, at least.
And do you have any?
Maybe I'll try it
questions?
again. I'll try it again, maybe. Maybe it'll help this time. Yeah.
yeah, because they change every year. They actually recently just changed for this year and, circumstances change too, so.
Try it again.
Any other questions about, we talked about a lot of different topics.
Yeah.
A quick question, and if it's too deep, just let me know.
Sure.
What is the Texas law on beneficiaries on heirs of an estate? If you have a situation where your child is not, you're not listed on your child birth certificate.
Okay, so and you're talking about like,
So say
if there was
for
no,
example, a father wants to leave something to his child,
Mhm.
and he's not listed on their birth certificate as the father. What are some means of how would they go about proving that I am his child and I'm by Texas law and heir of his estate?
and so that's a case where you're saying the father did not have a will,
No
it's just
will,
been
nothing in
tested.
place.
Yeah, so it depends on the facts of each specific case, but, so we can't give you advice on like a specific scenario, but it depends on who was still living when the father passed. And so the way the estates code spells it out is it passes along to your heirs in a certain order. So if father still had a living spouse, then spouse would get a share, and then he had children from one marriage, then those kids could get shares, and children from another marriage, then those kids could get shares. And it would all be divided differently based on who was alive at the time he passed and died without that will. So it's really hard to answer that question because that child is likely entitled to a share. But what percentage share they're entitled to depends. And then how they can prove that connection, that paternity was actually valid for them. There's a couple of different ways that they can do that. If there was never a DNA test before they pass, it usually gets pretty complicated, or any ordering them. It doesn't necessarily have to be on the birth certificate. It could be ordered by the court. So let's say, even though they weren't on the birth certificate, at some point, a court found that they were the father and ordered them to pay child support. Then that could be a finding.
Ever listed paying child support, that would be one way of proving, current.
Yeah, that could be a piece of proof for a parental relationship, yeah.
Sometimes, the court may order DNA test of the siblings of the deceased person, just so they can kind of link it. You know, they can bring in witnesses, people that knew the decedent, as he talked about, John Doe Jr. being his son, you know, or, you know, it's not only just DNA testing, but also, testimony from witnesses that knew the relationship. And, sometimes there's even adoption by estoppel. That's a whole nother theory where, maybe he wasn't even the, and I'm saying he, we talked about, maybe he wasn't the biological father, but he treated that child as a child of his own and intended to adopt him at some point, and he died before that. So that's another way to make an argument that this child would take a share of the decedent's estate. So there's different theories, and it's very fact specific. And the size of the share is also very fact specific.
Yeah, it's not like a bright line option, like where you can say, well, if not on the birth certificate, then this has to happen.
Right.
It's basically proving it up by establishing paternity using one different way. Like Maria said, there's tens, maybe hundreds of different ways you can provide evidence to support that, some more formal than others.
And just like a side note, just when, even if a parent or a father usually is the case,
I say father because usually in most cases, the mother has a baby, she right there, her name will be on it.
So, just because a father is listed on the birth certificate, that's not necessarily enough to declare or acknowledge the paternity. So that can always be challenged. And same goes to when the father is absent in the birth certificate, that's not enough to kill a case that this person was not the father, therefore the child is not going to take a share. There's other ways to prove that.
Any other questions?
The blue ink is for the living will, not for the holograph, right? The blue ink.
Blue ink for holographic wills, yes. And
the
honestly,
holographic will too?
yes,
Blue ink.
Blue
all
ink.
the way.
blue ink.
It's not a requirement, it's a recommendation, just to distinguish a copy from the original.
Okay, blue ink all the way then.
Generally, anything you want to make clear as an original, I would say use blue ink, it's safer.
Blue ink.
My last question was to say the person that the principal has to write the will, does that mean it has to be handwritten?
If it's a holographic will, the testator has to use the handwriting entirely in the whole document. So there may be some fillable forms online, and that's not going to count as a holographic will. That's going to be talked as invalid. It has to be entirely in the testator's handwriting
Okay.
for a holographic will.
And you can't transcribe it, like have somebody else write it for you. It has to be completely in your own personal handwriting.
Thank you then.
All right.
Thank you for coming.
Thanks, everybody. Those are really great questions. I appreciate you attending and asking those great questions.
And your first name is
Maria,
Maria Peter, okay.
do you have any questions?
No, I'm just interested in.
Okay, and then you were removed from math to ask this. I wanted to make sure you had the opportunity.
Now, I'm very